Okay, so you got an idea about the trademarks. So now I will definitely, as a form of intellectual property rights, why not to discuss about the mode or way to create a right. So trademark right, trademark right, trademark right. Because intellectual property rights, if you don't know what is the right, so this is this is worthless to learn intellectual property specifically. Okay, so now what I will discuss about trademark right, specifically how to create rights. Just like say if you compare with other forms of IP already, that copyright the registration is not compulsory. Industrial design registration is a compulsory, and first based on first to file systems for industrial design and for patents. If somebody files first, he will get the rights over that. Okay, so now for trademarks, now you will get little bit difference from whatever things we have discussed till date. Okay, so now for trademark, registration is not mandatory. Okay, so trademark rights we can generally consider, I put it as a use based right, use based right. Okay, use based right. Somebody use that trademark in the goods in the course of trade, then also automatically he will get rights over that trademark, and he can use that trademark in refers to the good. So sometime use means we consider prior use. Okay, just like say example, let's say you want to trade, just like initially just like you are entrepreneur, you are now manufacturing some good. Now you have to select a trademark. In that case, you have to be cautious. You should not use a trademark which is already available in the market. Market means not only Indian market. Markets means you should consider the global context also, because there is a concept called well-known trademark. So in this case, the prior use, although prior use always we consider with reference to India. Okay, use in India. So you have to select a good trademark which is not in prior use. Although registration is not compulsory, but you should consider a prior use which should not be in prior use. Means you should, there also there is a role of search. Okay, just like industry design, there is a search. Patent definitely search, utility model definitely search, again here the search. So you have to search that whether trademark already in a prior use. So trademark search database is also available. So sometime based on TM search. Where from? Okay, so you can search from the trademark office sites. You can search from some databases, available search databases. Okay, so search is also required before use of the trademark, because although registration is not compulsory, but what something is already in prior use, then you will be liable with reference to the use of the trademark, that trademark which is already available in the prior use format. Okay, so that way that say trademark in the form of a prior use. So use based right, prior use, and trademark search. So these three components you understood. Okay, so trademark registration is not compulsory, but registration will give a better protection. I am trying to mention that part. I will just try to analyze little bit. Okay, what way that registration will give better protection? Registration will give better protection, because registration registration already referred with reference to the copyright will give evidence of ownership, evidence of ownership. Okay, evidence of ownership will be provided by registration, and also if you are a registered proprietor, you can file a suit for infringement. I will analyze that part, infringement. Okay, simply you have the certificate by virtue of that you can file an infringement suit. But if you are a prior user, you have to prove then that your trademark is having enough goodwill, so that for prior user can file a suit called passing of suit. Okay. For passing of suit, he has to prove that the trademark have just like a goodwill. So, your trademark should have enough goodwill. Then somebody is just like using your trademark, use, then that lead to the erosion of goodwill, erosion of goodwill. Okay. So, that way this is better compared to that use based right. Okay. Use based right, use based rights, registration and use. So, use will be compared to registration based right, use will be compared to the use based situation. Registration based situation is better for you. Okay. So, that the part for trademark rights. So, just like say trademark rights is use based right, registration is not compulsory. So, prior user rights generally prevails over the others. Okay. So, registration better protection you can refer. Okay. So, then trademark. So, just like when we consider any kinds of intellectual property rights, so always we are considering the criteria. Okay. So, whether when we consider registration, then we have to think about the criteria. Okay. The criteria for registration is the just like a patent we call novelty, industrial design, newer original, copyright original. Here we put in layman understanding the distinctiveness. Okay. Distinctive. So, distinctives means should be have marks should be capable of distinguishing the goods. It should have capacity to distinguish. Just like Apple for computer, there is no problem, there is no relationship. Apple for apple juice not really distinguishing, okay, because Apple for computer there is no relationship. The word apple and the computers is called inherent distinctive. Apple for apple juice or apple related product may be the problem day one, because not inherently distinctive. Some attributes of the mark is embedded on the goods. So, that way it is not called, generally we call that is not inherently distinctive. Few cases that descriptive mark can be distinctive based on use. By long use, people will ultimately forget about the descriptive attributes of that mark. They will thought about, let's say consider Microsoft. Soft is for software, but Microsoft we are forgetting about that software components. We are forgetting that we are considering Microsoft is the brand. Microsoft is the provider for the Windows. Okay. And Window per se is also may consider as a trademark, just Window 95 or whatever format is coming up. Okay. So, that way that what we call the distinctiveness is the criteria. So, marks should be capable of distinguishing the goods or services. Capacity means it is capacity in a day one, means inherently distinctive. Capacity by virtue of use, just like even place name can be a trademark by virtue of long use. People will forget about the place name, people will thought about the this is as a source of goods. So, when that actual name people will forget, then it will be have the capacity to distinguish. So, it has called acquired distinctiveness. One is called inherent distinctiveness, another is called acquired distinctiveness. Apple for apple juice, inherent distinctive, that or say Microsoft may be for even for software is not acquired distinctive, say inherent distinctive. It is had acquired the distinctiveness, because soft means software, some relationship is there, maybe a coined word. So, that some relationship, so acquired distinctive. Similarly, place name as a trademark may be a trademark based on the acquired distinctiveness. Okay. So, that mark which is just like the second criteria is that. So, when respect of say we call two criteria, absolute grounds of refusal of registration, the section 9, and another is called relative grounds of refusal of registration. So, absolute ground, if some mark is not distinctive, say that and some mark has capacity to distinguish by virtue of long use, those mark will be registered based on the grounds of section 9. and if some mark is not distinctive, then that type of mark is not, or descriptive, that type of mark fully descriptive may not be registered as a trademark, including that let us say a mark which is obscene, which is hurting the religious sentiment, just like say Meenakshi for shoes may hurt the religious sentiment. That type of mark will not be registered, just like which is obscene, which is hurting religious sentiment, which is protected by Name and Emblem Act, just like say national, just like say Ashok Chakra, or similarly some others countries national flag may not be in India also may not be considered as a trademark, because that is come under the purview of Name and Emblem Act. Similarly, the Name and Emblem Act can prevent the president as a trademark or Prime Minister word as a trademark. So that come up under the Name and Emblem Act. Similarly, relative grounds section 11 suggested your mark, if you select a mark and that mark have to compare with the earlier trademark, and that lead to create confusion, on that grounds your marks would be not be registered. So, visual, aural and conceptual similarity you have to judge with reference to the prior mark, on that case relative grounds of refusal, just like amoxyl, limoxyl, gluvita, glucovita, gluvita, glucovita, amoxyl, gluvita, 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 glucovita. So, gluvita is there, glucovita, then I have to consider that relative grounds between the before registration, that whether that lead to the create confusion among the minds of the customer and consumer. So, leave T, leave 52, leave T, leave 52, leave 52. So, understanding that the some sorts of similarity with reference to what? Visual, aural and conceptual similarity. So, visual, aural, conceptual similarity have to be considered with reference to the confusion. So, I have to consider relative grounds with reference to that mark, which is marks which is with reference to the prior mark. So, registration criteria simply distinctiveness or capacity to distinguish. Capacity to distinguish on day 1 inherent based on origin, acquired based on use, and that second ground we are telling that should be its mark should have that with reference to that earlier trademark. If that earlier trademark with respect to that, if he is not creating confusion, so then it can be considered to be registrable. So, in that ground that whether create confusion and others, there lies the role of again the survey people. So, they have to go take a survey from the market whether there is really creating confusion or not. That type of evidences you may have to produce to make your mark registrable with reference to the glucovita, glucovita, glucose D, glucon D, all those kinds of situation. Understood. Okay. So, even there is a ground called ground that say is a called well known trademarks, just like say some mark Pizza Hut is well known in India, but there is no use of that mark in India, but on that grounds also that somebody may not be allowed to register that mark, considering that is a well known trademark. So, because that will create a confusion between that Pizza Hut as a trademark and respect of others. So, similarly here the ground suggested which consists of some quality or say 10 gram packet you are selling some goods and you are telling that 10 as a trademark you are using, then some kinds qualities or intended purpose or value that you are trying to reflect through that mark, then that may attack on the absolute grounds of refusal of registration of trademark. Okay. So, some mark is some word is customary practice, that cannot be allowed to use as a trademark because that is a customary practice, just like a khandua or some other part that may not be allowed as a trademark. Okay. So, now come to the procedural part of registration of the trademark. So, understood now what criteria you required for a trademark to be registered, distinctiveness, and just relative grounds you have to think about. But here a few other elements also you have to know, just like say a chemical name or IUPAC name cannot be registered as a trademark. Okay. name as a trademark. So, if you understood that place name based on the acquired distinctiveness criteria can be a trademark, not inherently distinctiveness. So, Darjeeling tea is not considered as a trademark in the day 1, but subsequent use may lead to create a distinctiveness can be a trademark. Okay. Similarly, the personal name, there is issues, the name or surname, how it can be registered, or some popular name we want to use as a trademark, including character name, or just like Gobber as a trademark, or Tarjan as a trademark, the character name, or some popular name used to under trademark. In that case, you have to take permissions from the person or his legal heirs. Okay, just like Tagore as a trademark, that the issues lies there. Okay, so generally for name kinds of situation, the procedure suggested name should be rare name instead of common name, because understood there lies the issues. So, but there lies the different issues of reference to name as a trademark, but we are not discussing regarding that. But now let us come to a registration part. Okay. So, trademark registration component. Trademark registration means who can apply for registration, that like say a proprietor or owner can apply for registration, or how to register the trademark means let us say a particular forms with the fees, and you have to give that representation, what marks, what is this word, label and logo, you have to give a representation of that mark, that your mark have to be pasted in a A4 size paper. Okay, and I have to produce along with the application forms. Okay. So, who can apply? Any person can apply for registration of the trademark. Okay. They hit any persons means the persons from India or even abroad can apply for registration of the trademark. Okay. Where to apply? A particular registries are there, just like Delhi, Calcutta, Chennai, Ahmedabad, Madras, Mumbai. So, these are their trademark registries are there. Based on the address of service, you can apply in any appropriate offices. Then what we will do, the appropriate office give you an just like say for like other forms, they will give a number, application number, then data entry, scanning, verification, then they will examine your trademark on the grounds that whether it is really a trademark, and then second case that whether trademark just like the grounds of distinctiveness or not. On that ground they can send you an objection. Okay. Or if they could not found any grounds of objection, they may accepted it. So, if objection raised, then you can have to meet the objections within a statutory within a specific time frame, or you can go for a show cause hearing. Then in that case, if hearing based on hearing it is accepted, then that it will go for journal publications. It will published in the journal, trademark journal, that generally come up from the trademark office. In journal it will be published. Okay, this trademark, this is the proprietor is registered, that which class means I have to mention again, I forgot to mention, we follow nice classification of the goods, which class of goods means let us say consumer goods or other goods, that class you have to refer the class, which class you are registering that trademark, then a class of goods, then it will be published in the journal publications, then it will go wait for opposition within 3 months, that can be extended for another 1 month. Any person can oppose, any persons means any person from any other countries can also oppose the registration of the trademark. Okay. So, any person will can oppose the registration of trademark when in 3 months, that can be extended for another 1 month. If opposition there is no opposition, then it will be again it will be registered. If no opposition, then it will be registered. So it will be registered. If opposition decided in favor of you, also it will be registered. But in that case, the opponent can go and appeal before the appellate authorities. Appellate authorities also. Okay. So that way your trademark will be registered. So now, if registers it your form that another part. So you register it register for 10 years. Now every 10 years you have to renew your trademark. Okay. So if you your trademark is registers, then after 10 years, every 10 years you have to renew, then your rights will be perpetual. So remember that trademark rights is perpetual based on renewal, means if you renew your trademark, okay. But another ground is that if you don't use your trademark, that you may lose the rights. Just like patents non-working ground revocation. Similarly, non-use ground led to the rectification or removal of the trademark. So, now non-use of a trademark for 5 years may lead to the removal of the trademark from the register of the trademark. So, remember, if you are a trademark owner, you should use the trademark. Use means use in the course of trade, means amount of use is not substantial, but even single sale of the good bearing the trademark will be considered as use. If you read the case, just like say, let us say Vodafone and Hutch. So, Hutch was know that a good trade brand, Hutch trademark is not in use. We may not, if not in use, then automatically Hutch trademark may be abandoned. Similarly, a lot of other situation may got it, less like say Allen berries or other kinds of situations. So, if that trademark is not in use in respect of goods, then automatically 10 trademarks will be abandoned. Okay. So, somebody want to use that abandoned trademark, so that will be considered based on first use basis, first come first serve basis, or first use basis. Okay. So, that way the trademark part. So, registration 10 years, then renewal. So, there is also procedure like a restoration, that the post grant prosecution of the trademark. There is the amendment, and within the scope, amendment should not enlarge the scope of rights. That amendment is also possible. Then another components on that, so that is called trademark transaction. There lies the issues with reference to the trademark, just like whether trademark can be licensed. Okay, just like I told, a source identification function and quality identification function. So, now trademark owner giving somebody trademark on license, then whether the licensee will able to bear will to maintain the same quality whatever the trademark proprietor was maintaining. So, there lies the issues or reference to the trademark licensing. Okay. So, trademark transaction you understood. So, in trademark transaction components. So, registration part we have discussed. So, registration part we have discussed, that is this is the trademark say enforcement of rights, so that we are not discussing now. So, now transaction is an important parameters for let us say managers, people, just like if you are working as you are technologist or engineers in work in an organization, and then just like say another you are say marketing managers or so brand promoter or advertiser, this type of management job you have to do in an organization, then they have to should know the important parameters called trademark transactions. So, that way that so licensing and assignment. Okay. Just like say in Indian context, now in respect of trademark, if you nice way analyzed, so as the registration is the module, but why not registration? Along with the registration, we can discuss the transaction components also. So, now in a simple mark, let us say Apple. Okay. So, the one is the simple word Apple, but not only the word Apple, then with that word we have some goodwill. Okay. So, then that part we are discussing, that okay, when you give the license, whether that goodwill is also will be goes to the licensee or not. Okay. Because for that reason, that's like the clause called quality control clause, that will ultimately protect the interest of the licensor or owners, and that will also protect the interest of the consumer. So, that way the quality control clause may be essential, or I can say, or somehow that sufficient connection, the theoretical or jurisprudential, so sufficient connection should be established between that. Okay, just like say, okay, that product manufactured by such trademark license to Mr. That company is selling or product based on that using this trademark based on the license agreement. That sufficient connection you have to be established between the licensor and licensee. That way you can defraud, prevent people protect people from protect people from fraud, protect people from fraud. So, now what we are discussing, the Apple word, not only the word, along with the word we have now goodwill. So, if you allow somebody to license the word apple to be used in a particular course of trade, then the issue is coming up whether you are assigning the things along with the goodwill or not. So, with or without goodwill, that is the important parameters. So, generally the act suggested. So, goodwill is also sometimes people suggested this is the important parameters as a technical graduate. Goodwill is also considered an intangible asset. Intangible, I-N-T-E-N-G-I, intangible asset, separate from simply the word apple, because based on that use it has acquired that intangible assets, intangible assets. Okay. So, that way intangible asset. Okay. So, intangible assets. So, that way that how to build an intangible assets, important parameters, how to build an intangible assets, based on that's there lies the brand valuation. So, intangible assets. So, that way that you can assign the trademark along with or without goodwills. What is goodwill? Goodwill is another form of intangible asset. So, you can separate the mark from goodwill that indicated, but really it is very feasible to separate or not, there lies the issues. Okay. So, goodwill, so trademark can be assigned with or without goodwill as per Indian Trademark Act. Okay. Similarly, licensing also trademark can be possible, but I will advise that you should maintain a quality control clause, and when you are taking in your organization, if there somebody your organization is taking license of particular trademark, or you want to give some license of your trademark to other persons, that part either try to give some in the license even give some create sufficient connection, or give a quality control clause, just like say nowadays how they are doing business, just like say says like say KFC, or let us say what is that just like say, just like KFC is KFC, then other brands they are doing business by means of franchisee. They are maintaining a sufficient quality in all the stores in different jurisdiction, just like Subway, I forgot to Subway, KFCs, then Cafe Coffee Days. They are see that wherever you go that they have same get up, same quality control they try to maintain. For that reason they are protecting the goodwill in across the jurisdiction, and they are good brands. So, that part sometimes we call franchising of franchising. Okay. That is the important parameters with reference to the trademark transactions. Okay. So, we have discussed about registration of the trademark. Okay. So, registration of trademark, who can register, we discussed. What criteria required to register, we discussed. Okay. So, now what criteria required to be discussed, we required to be register, that discussed. Then we required what we required to discuss, that already we have completed the discussion with reference to trademark. Next class we will discuss few other elements of the trademark, trademark, then we will go to the others forms of intellectual property rights. Okay. Thank you.